The Federal Trial Practice Seminar began in 2010 with two goals in mind. First, to train lawyers with less than 10 years of experience in all the key aspects of trial practice. And second, to convey the court's expectations to young practitioners who will remain in Delaware, thereby ensuring a continued high level of practice in the district court.
The best thing I can say is you're never going to get that experience that you need to try a case without actually doing it. And this program is the best opportunity for you to do that.
The Federal Trial Practice Seminar is held once a week for 7 consecutive weeks. 5 of the weeks are speaker-driven sessions, containing a presentation from one of the judges or from one of the 4 invited nationally recognized speakers. The topics covered over these 5 weeks include courtroom presentation and demeanor, opening statements, closing arguments, direct examination, and cross-examination.
I don't know why, but you should raise your voice, you should lower your voice, you should talk to them. You're having a conversation.
The remaining 2 weeks are devoted to practicums, where the Federal Trial Practice Seminar participants will practice the skills they've learned in the speaker-driven sessions and receive feedback from experienced practitioners serving as program mentors and from the panel of district court judges.
You know, you want to say they're lying without saying they're lying. So you say, Prince, when interviewed by Detective Armour, said that he bought the car 4 days before. But the evidence will show that he bought the car 10 days before.
Presence here and should take better advantage of those things. I'm not sure if you conveyed true commitment to your position. In fact, it struck me at times, I don't know if he really believes what he's saying.
The Federal Trial Practice Seminar culminates with a 1-day mock trial put on by the participants using mock jurors from the community. Each trial is presided over by a judge from the district court, and the participants are able not only to receive feedback, but also to watch the deliberations on video and speak to the jurors afterwards.
Got defensive, and that to me was, I didn't like it.
This kind of thing is very emotional. Right. You know, you see this poor man and his wife has brain damage, and you know, right. You stress the fact that you have to stick to the facts. Right. Because I was having a hard time separating from the emotional part of it. And the daughter won't go see her, and the husband, you know, doesn't have a wife anymore.
And we were also talking about emotional, like they told her she was dead, and then they come back and say she's not. So that right there, it was, you know, you're like, well, they should pay for whatever. I mean, that's
has been a positive impact. I mean, people at my firm are aware I've completed it. I've even had co-counsel from out of town ask me about it because it's on my little firm bio. But, you know, it just, I think, accelerated my development. You know, it's a cliche, but young attorneys don't get a lot of opportunities to stand up in court these days, especially early on. I've had co-counsel come into town, you know, in their 8th and 9th year and say, you know, this is my first big argument. So, yeah, I think it accelerated by a few years what I might have done otherwise.
The most challenging aspect of the program was overcoming nervousness to speak in front of a federal district judge or a courtroom filled with federal district judges and mentors and my peers. And so I think when we had to do our first practicum, I think it was 2 or 3 weeks into the program, and we had to get up there and give an opening statement, and to be clear and concise and make sense in front of a whole bunch of people you don't want to look silly in front of was probably the hardest part of the program.
I'd practiced for several years before, at least a couple of years before I had participated in the Federal Trial Practice Seminar, so I felt like I knew some of these things, but really getting to the Trial Practice Seminar and actually having to get up and do the opening, I was really, really nervous. And I think the practitioners made us at least feel comfortable, and that's a natural way to be, and explain how that kind of helps with the presentation sometimes. But I think the tough part, and the part that's probably even more valuable than that, was the critique. I mean, the candid, at times tough criticism and pointers and that kind of thing that when we did our practice opening, we got that kind of feedback. And then when we actually did the the full-fledged opening for the program or a different piece in the program, it was very valuable.
One of the things I thought was particularly valuable about the program was the outside speakers coming in, people that are really experts in putting on a trial, coming in and talking to us about putting on directs and crosses, and then being given the opportunity to do that very, very shortly thereafter. Doing a direct and a cross, I think for a lot of, especially associates at big law firms, is something that is not, it's difficult to get that opportunity. And so having an opportunity to do it after being instructed by expert lawyers in front of judges, real judges that I would actually be practicing in front of, gave me a real opportunity, and it allowed me to push for those experiences in real life. And I have since gotten quite a few of those experiences in real life.
Our efforts and the difficulty to get accomplished trial practitioners to participate in the program, we've been pleased and grateful that it hasn't been difficult at all. In fact, we've really been humbled by the fact that so many top trial lawyers in the country have agreed right away to come into Delaware and speak to these young lawyers that they may never see again, because I think they respect our court, but also I think because they really do themselves have an interest in teaching. And a lot of these top trial practitioners are folks that have taught in some way throughout the years, either taught members of their own firms or taught others through programs like this one. And I think that's led to the fact that they're so interested in being a part of this.
There were a lot of things that I learned in the Federal Trial Practice Seminar. Probably the most valuable was that there is no one way to do things in the courtroom. Each judge has his or her own preferences, just as each practitioner has his or her own strong points. So probably the best thing that I learned was that each litigator or each person presenting in a courtroom has their own style, and I shouldn't try to adopt a style that may work very well for someone else and it might not work for me. So it was kind of, a nice way to figure out what worked best for me, find my own courtroom voice, test it out, and then get feedback and try to hone it down to something that makes sense or works in the courtroom.
I think the most surprising aspect of the program has been how much I've learned from the speakers who come in, because it's one thing to see lawyers try cases, but it's another thing to have access to the reasons why they practice a certain way. So it's been an educational experience, I think, for all of the judges. And it's always wonderful to see young lawyers come in at one level and truly benefit, and I think they all do, from the first exercise to the trial exercise. They really do develop this confidence and this comfort level, and I think so. It's been educational for us, and it's been very meaningful to see the growth, professional growth, in our lawyers and the degree of confidence they have personally as well as professionally.
There is no better way to get feedback, honest feedback, in a risk-free environment where you have everything to gain and nothing to lose, from judges that you will practice in front of for the next 20 or 30 years of your life, and from lawyers in the community that the judges already respect. It's a great way to get to know the judges, to get to know the bench and bar, and I would absolutely recommend it to anyone.